All right, good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Kaylin Cheatham, Michelle Daly, Nicholas Duncan, Max Juarez, Guy McSpadden. I got Mr. McSpadden appearing via Zoom for Sanctions Court. Maria Malicio. I believe that she's here. I see her. Joseph Moreno. Joseph Blake Moreno. James O'Brien. Isaiah Rosser. I have a note that Mr. Rosser will be late. We'll recall his case for Sanctions Court. Shacole Sampson. Shacole Moniz Sampson for Sanctions Court. Caleb Waller. Note that Mr. Waller's in the hospital. We'll recall that case. Brandy Chevalier.
Your Honor, she's homebound in Bossier Parish.
All right, we'll recall that. Juan Wilkins. Emerson Abbott.
Here.
Sean Davis. Isaiah Madrano. Here. Matthew Powell. Jana Prox. Wyatt Berkwin. Now that he is in TDC, we'll recall that case. Trevion Bowie. Now that Mr. Bowie is in Smith County custody, we'll recall that case with Mr. Schmidt. Darian Dotson. Darian Dwayne Dotson. Shunta Foster. Show that Ms. Foster is still in custody in Gregg County, I believe. Is that correct, Ms. Abraham? Gregg County? Yes, sir. All right, we'll recall that. Will she be appearing by Zoom today? Do you know? We're just here on the competency. Gerald Holmes. Harold Morgan. Anthony Murray. Anthony Wayne Murray.
Last time I spoke to Mr. Murray, he's federal custody. Received the sentence of
Okay, we'll recall that one. Evan Page. Ladary Ward. Ladary DeAnthony Ward. Amanda Wellborn. Ray Williams. Morris Moreno. Morris Lee Moreno. John Ross. Thanks, sir. LaRonda Alexander. Wesley Ball. Obed Mingastu.
Your Honor, Mr. Mingastu is in Dallas County.
Yes.
State checked on that yesterday. I believe he's got a hearing where they confirmed that yesterday. He's got a hearing, I believe, on the 18th of December. Mr. Hartwell and I'll know a little bit more after that hearing about what Dallas's intentions are.
Okay, I'll recall that once you're ready on your cases and we'll get it reset. All right, is there anyone in the courtroom, your name's not being called? All right, do we have any counsel that's ready? Any counsel that's ready, Mr. Schmidt, you ready? Sure.
Mr. Ross, Your Honor.
Isaiah Rosser.
John Ross, Your Honor.
Oh, John Ross. I thought you said Rosser. John Ross. This is cause number CR 24-224, State of Texas versus John Robert Ross for pretrial. Go ahead, sir.
Yes, Your Honor. We're just asking for a reset to finalize negotiations with the prosecutor's office to
So you've received all discovery?
Yeah, I believe I have, yes.
Okay, and you're not requesting any type of pretrial hearing,
No,
any
no.
issues?
No,
Okay, all right, then the court will set Mr. Ross for a docket call, give you time to finalize your negotiations with the state. All right, are you available on January 7th or 9th?
The 9th would be good, Your Honor.
9th, okay. Court sets Mr. Ross for January 9th at 9 a.m. And Mr. Ross, once you sign your notice of setting, you're free to go.
He has, Your Honor. Thank you, Your Honor. Are we free to
Yeah,
leave?
free to go. Anyone else ready? Mr. White, you ready?
I'm ready, Your Honor.
Who do you want to call first?
We can do Miss Alexander.
LaRonda Alexander, CR 24162.
I'm sorry, Your Honor. What was the cause number on that?
CR 24-162.
Your Honor, we had asked the court previously to set this for pretrial again because we had, we're trying to get, a disc of the, in-car video, which we've received and I've viewed. I'm gonna be filing a motion to suppress on that and I'll need a hearing.
Any objections from state for setting for evidentiary hearing on motion suppressed? You haven't filed it though yet, correct, Mr. White?
I believe we were filing it this morning. If it may not be, but it'll be filed by the end of the day for sure.
All right, court will set Ms. Alexander for motion to suppress on January 23rd at 9 a.m. And once she signs her notice, she's free to go. I would say let's double check. All here. Mr. Ball.
Yes, sir.
Wesley J. Ball, CR 23232. Mr. Ball set on pretrial.
Oh, there you are. If the court will recall, last time we were here, we had asked for an additional pretrial due to the fact that we hadn't had our expert look at it. I've received my expert's report. Right now, I don't have any contested motions on file. We'd ask the court to move it over to docket call. We'll abide by the court's standing pretrial order.
All right, you available on January 7th or 9th?
Previously, haven't spoken with the court about my situation. I'm not sure yet, Your Honor. I'll know more this week.
What about January 21st?
Yes, sir. Well, let's go ahead and put it on that day, and if we need to address it, we will.
All right, court will set Mr. Ball for January 21st at 9 a.m. for docket. Court call CR 24143 State versus Obed Mingastu. Court will reset Mr. Mingastu for pretrial hearing on January 21st at 1:30. ahead and say from 1:30, Mr. White. Is that all you have this morning?
Yes, sir.
Mr. Adams, you ready?
Yes, sir.
Brandy Chevalier, CR 18467. And go ahead, remind the court, you said she's homebound in Bossier Parish, Louisiana.
Yes, sir. We have, well, my legal assistant has spoken with her brother on several occasions. From my understanding, she was put into a hospital in Shreveport with after suffering a significant stroke during the summertime. We have some records regarding her hospital stay that I think we've provided to the court. Beyond that, I don't have any other documentation concerning her that documents what her current health situation is, save and except for what we are told by her brother, which is that she is now bedridden and uncommunicative as a result of the stroke that she suffered. I understand from her brother that I'm not able to have any kind of meaningful conversation with Ms. Chevalier. What I can do is round up whatever documentation is available that would establish what her current situation is now. I understand that she may be in the care of some palliative nurses or something to that effect. I'll see what I can do to maybe track down the agency that's providing that care for her and provide that to the court and to Ms. Curry's office. I know this case is now about a dozen years old. I think I might have been given the discovery on a floppy disk. I don't know, but we'll find a way to do something with it. I don't know what that's going to be, but I don't have a reason to think that her brother's lying to me.
Okay.
And she's only 37 years old.
Let's reset to January. Do you have anything? Let's reset to either January 7th or 9th.
The 7th would be, I guess, a morning time.
We can, yes, morning.
That works for me.
All right, the court sets Ms. Chevalier's case for status. January 7th at 9 a.m. And Mr. Adams, if you can get us something definitive on her medical status.
Yes, sir. We'll dig up something.
Is that all you have this morning?
This morning, yes. I've got one this afternoon. If that's going to be at the jail, I guess.
Randy, ready?
Yes, Judge.
Who's our call first?
I think call Mr. Sean Davis.
Sean Ray Davis. Cause numbers CR 2395, CR 23207, 208, and 209. I believe that we're set on status today.
Yes, Judge, we're ready to proceed if we can move to docket call.
Okay. You available on January 9th?
Yes, Judge. Is that Thursday?
Thursday. All right, court sets Mr. Davis for docket call on January 9th in each case, 9 a.m. Once he signs his notice, he's free to go.
Thank you, Judge.
Hold on, sir. Who would you like next?
Next, ready on Mr. Madrano.
Isaiah Madrano, CR 24-218. All right, Mr. Madrano set on pretrial.
Yes, Judge, we have no contested pretrial matters at this time. We'd like to move forward to the docket call setting.
All right, court sets Mr. Madrano for docket call January 9th at 9 a.m. All right, I want Mr. Madrano to check in with Mr. West, the pretrial release officer, to address some delinquencies in his financials.
Yes, Judge. Would you like for him to go around outside or,
Let's see what Mr. West wants to do here.
sorry.
Talk in this one? Okay. He's free to go.
All right.
Who'd you like next?
Next, ready on Mr. Powell.
Matthew Lee Ryan Powell, CR 24-219. Powell set for pretrial.
Yes, Judge, we have no contested pretrial issues at this time. My client has decided he would like to accept the state's offer and would request to be set for a plea.
Do you want to do that sooner or later?
Judge, we can do that on January 9th.
All right, court sets Mr. Powell for plea before the court January 9th at 9 a.m. I'm assuming it's a morning plea?
I'm sorry, Judge.
Morning plea?
Yes, Judge. Judge, I have paperwork on Mr. Abbott and I will be speaking with Ms. Prox and then be making another announcement.
Okay.
Judge.
Mr. Lewis, are you ready?
Judge, I've handed some additional information to the prosecutors. They have not had a chance to review it.
Okay.
Um,
Is that something that y'all are going to be reviewing today, or do we need to go ahead and call the guys?
We have it right here, Your Honor. We were just about to
Okay.
discuss it in light of the fact that counsel will be sitting behind us.
Okay.
So we just have a few more minutes.
I'll recall it. No,
Thank you very much, sir.
Is Morris Moreno here? Morris Moreno? Let him know that he wants to just zoom in and not have to make the trip. I'm fine with that. Yeah, he's in Athens. Just let him know not to head this way. Let's see yours for this. Michelle Daly. All right, good morning, Michelle. How are you?
I'm fine, how are you?
Doing fine. All right, looks like you complied with the previous orders of the court. So we're gonna do another sanctions court hearing, $100 to court collections and $100 to probation, okay? And we're gonna set that on All right, Michelle, we're gonna set you for January 7th at 9 a.m. So make sure that you have your payments made the week before. Okay?
Thank you.
You're welcome. Nicholas Duncan. All right, good morning, Mr. Duncan. All right, looks like you paid your sanctions. You paid $100 to court collection, $100 to probation. We're gonna do the same thing again and come back on January 7th.
Okay.
Okay. All right, we're gonna bring you a notice here, sign that, and you're good to go. Mr. Cheatham, come on up. All right, Mr. Cheatham, looks like you're doing okay. You paid your court collections, you did your probation fees, and you did your 15 hours community service. Let's see. If I upped your community service. Hang on, let me think about this for a second. All right, so this is what we're gonna do. We're gonna have you come back on January 7th. And we need to do 170 to probation. It's an additional $20. 170 to probation, 100 to your court collections. And let's do 15 hours community service. Okay, easy enough? Yes, sir. All right.
Thank you, Your Honor.
You're welcome. Have a good day, sir. Mr. O'Brien. James, how are you doing?
Good.
Doing good?
Oh, yeah.
Good. All right, looks like you did well. You paid your 200 to probation, your 200 to court collections, did your 20 hours community service. We're gonna kind of just stay on that same pattern until we get you caught up and to a point where we can let you just get back on regular probation, okay? All right, we're gonna come back on January 7th, same thing, 200 to probation, 200 to court collections, and 20 hours community service. Max Juarez. Is Max Juarez here? Go ahead. Okay, that's right.
Hello.
Mr. Juarez, can you see and hear me?
Yes, sir.
All right, this is your sanctions court hearing in cause number CR 23-185. Let's see, Mr. Juarez, my notes say that you were supposed to do several things. I was gonna allow you to report by Zoom today because of your work schedule. But you had to pay $90 to probation, $75 to the district court for your collections, and comply with your 12-step program. My notes here say that you didn't pay either of those fees. Is that right?
How you say? I I thought I had to pay them earlier this month, but I seen that I did, so I had to today in the morning, early morning.
So when are you gonna pay those?
I paid them already. I paid them today before court.
I need you to pay those on time when you're supposed to, so that I don't have to try to figure this out during my court session. You understand that?
Yes, sir. I'm sorry about that. Yes, sir.
What happens on the job if your boss tells you to do something and you don't get it done? What happens?
Mm,
You
you
either
you get a write up or you get.
yeah, you get a write up or you get fired and you lose your job. And so I'm going
Yes,
out of my way here to let you keep your job. Okay? But
yes,
that
sir.
doesn't mean that you prioritize everything else over what I'm doing, because in essence, I am your boss, because without your physical
Yes, sir.
presence on the job site, you got no job. Okay? So you need to keep me happy like you're keeping your boss happy. And the way you keep me happy
Yes, sir.
is to do what I ask you to do. And I ask you to do things on time so that I can trust that you're doing what you're supposed to be doing. Okay? I don't want to hear, oh, I paid this
Yes,
morning.
sir.
Oh, I forgot. No more of that. You understand?
Yes, sir. I apologize.
All right. So I'm gonna have you report on January 7th. Are you do you know when you're gonna be back in town?
Uh, Here, let me check my calendar real
Yes,
quick.
but
I'm gonna be hopefully, most likely, I'll get off the 20th and be be in town from the 20th all the way to the 2nd of January.
all right. And then you leave back out. When do you come back after you go back out?
Mm, Probably like 2 weeks after January. It really depends how work is.
Could you be in town on January 21st?
Yes, sir.
Will you be there that day?
Yes, sir. Yes, sir. I'll tell my uncle right now. That way, it's with time and it's excused.
All right. So I want you to actually come to court on January 21st. Okay, in person.
All
And
right.
I need you, the week prior to that, I need you to have $90 to probation paid and
Mm-hmm.
$75 to your court collections.
Mm-hmm.
And then come here on the 21st and we're gonna figure out how to deal with your other issues.
All right. That's works.
Okay.
And you said the 21st, correct?
Yeah, January 21st. That should be, if you go back, if you're back at work on the 2nd, that should be the Tuesday after your 2-week haul.
Yes, sir. It is. All right. That sounds good.
All right, we'll see you on January 21st. Make sure you get those things done the week before.
Yes, sir. I will. Appreciate it.
You're welcome. We'll see you.
All right, you have a blessed day.
You too.
Ray Williams.
Mr. Williams, if you'll come forward. This is cause number CR 24-226, State of Texas versus Ray Anthony Williams for pretrial.
That's correct, Judge. I'm going to ask for an additional pretrial setting for Mr. Williams. Court will allow it.
All right, there being no objection from the state, the court will reset Mr. Williams. Be available on January 7th.
Yes, sir.
Court sets Mr. Williams for pretrial January 7th, 9 a.m. Mr. Williams, if you haven't already met with Mr. West, pretrial release officer, you did that this morning?
Yes, sir.
All right.
Maria Malicio.
Maria Edith Malicio, CR 15152. On motion to adjudicate, go ahead.
Judge, I was appointed this morning to represent Ms. Malicio, received a copy of the state's motion, and asked for some additional time on that.
All right, court, you want to set her on the evidentiary docket end of January, or you want to set her earlier, like January 7th?
End of January would be fine.
In January. All right, court sets Ms. Malicio on the motion to revoke docket January 23rd. 9 a.m.
Amanda Wellborn. Wellborn.
Wellborn. All right, this is cause number CR 24-122, State versus Amanda Marie Wellborn for docket call. Go ahead.
Judge, we're going to announce ready for trial at this point.
All right. And so Ms. Wellborn's done all her negotiating with the state, and has the state made any offers?
They have made an offer.
All right, that's being rejected today.
Yes, sir.
And what is that offer?
The offer was a reduction to a lesser included Class A misdemeanor family violence.
Was it time or probation?
I don't recall.
It was a 2-year deferred offer.
2-year deferred? All right, so your client understands that the court may not allow her to accept that offer at a later time.
Yes, sir.
All right, court sets Ms. Wellborn for plea.
Jury
I'm
selection.
sorry, for jury selection on, we'll begin that on. Begin that next Monday on the 9th. So Ms. Wellborn, next Monday, you'll report to the courthouse. You'll meet with my court staff. They'll go through, give you a notice of setting, pretrial release officer may be there. Mr. Schmidt's not going to be required to be there because you're not going to go to trial next week. But you're going to continue this process until you are reached for trial, okay?
What day was that, Judge?
Next week on the 9th. Monday, the 9th.
We'll just go outside and release that and go. And we'll do that. Yeah, right when we walk through security. It's bad. Evan Page.
Evan Andrew Page, CR 1963. Mr. Page is set for docket call.
That's correct, Judge. We'd ask setting for a plea on that January 7th date, if that's available.
All right, court sets Mr. Page for plea before the court January 7th. Is that a morning plea?
Yes, sir.
And then Mr. Schmidt, I would just ask that you get with the probation department or state to make sure that any pretrial deficiencies are going to be resolved either before or within that plea
Yes, sir.
on the financials.
Gotcha. Harold Morgan.
Harold James Morgan Jr. His cause numbers CR 24-105, CR 24-159. Sure that we're separate docket call in each case.
That's correct, Judge. We would like to set both cases for a plea on January 7th at 1:30.
All right, court sets Mr. Morgan for plea before the court January 7th, 2025 at 1:30.
So you won't come here, Harold, 7th. Right next door to my office.
Here you go.
Gerald Holmes. Can we approach on Mr. Holmes too as well?
Yes. Bill Twits in arms. Mr. Lee. Yes, please. All right, this is a sanctions court hearing. Isaiah Rosser, CR 21-239. All right, Isaiah, looks like. Looks like I gave you a couple of things to do. One of them was work 25 hours community service. Appears you did that. One was to pay 150 to your work collections and $70 to your probation. Were you able to do that?
I will be able to do it on the sixth, this Friday, when my check hits.
So you'll be able to do it this week
Yes, sir.
in full?
Yes, sir.
All right. And remind me, where are you doing your community service? Volunteer now?
Volunteer now, yes, sir.
All right, then what I'll do is I'll reset you, Isaiah, to January 7th. And we'll do $70 to probation, 150 to court collections, and 25 hours community service, the same that you did, okay?
Sir.
Remind me, you're working, right?
Yes, sir.
What are you doing? What work you doing?
Delivering appliances for Lowe's.
For Lowe's?
Subcontractor, yes, sir.
Okay, how long you been doing that?
Huh?
How long you been doing that?
I've been doing that since I was 19,
How old are you now?
23.
Do you like that line of work? Is that, you plan to stay with that or?
I plan on branching off and starting my own contract, through myself, instead of working under somebody else. That's my goal.
Sure.
Yes, sir.
Okay, good. All right, glad to hear it. All right, we're gonna have you sign this and then you'll be good to go.
What is the new reset date, Your Honor? My apologies. I wasn't.
For Mr. Russell.
Yes, sir.
It's sanctions court.
Huh?
It's gonna be January 7th.
Thank you very much.
Caleb Waller. Caleb Waller here. Oh, all right, we'll reset Mr. Waller for sanctions court, January 7th. And we will get verification of his hospitalization.
Your Honor.
Good morning, Mr. McSpadden. Can you see and hear me okay?
Yes, sir. Can you hear me?
Yes, sir, I can. All right, this is your sanctions court hearing and cause number CR 2236. All right, there's several things that we're gonna have to get done. I show that you were delinquent on your probation fees. You were insufficient on your court collection fees. No, didn't work your 20 hours community service. And we're still waiting on your medical records, I assume, from the VA, correct?
Yes, I was actually supposed to have a meeting with them today, but because of court, they're going to reschedule it. My probate, the deal on the fines, I planned on. I don't get paid until the first of the month, so actually, I've already paid $100 towards probation, and I was in the process of paying $100 towards court costs. I was just told it don't count because it's not. It should be like the prior of or whatever, but that's what's going on. But I plan on paying the $100 per each, Your Honor.
When did you,
And
let me ask you this. When did you pay the $100 to probation? You said it was after the first?
yes,
So
I get paid. I get paid on the. I don't get paid until the first, but I've already paid probation, which was earlier. I was having difficulties with the website, and I plan on paying the $100 towards my fees also.
Well,
And
when did you actually pay the probation fee? Did you pay that yesterday or on the first?
actually, it was late last night, Your Honor.
Late last night? Okay.
Yes, and I was in. I tried to go on y'all's website to pay that, but I was having difficulties. It wouldn't let me go through the series to put my information in. So I have $100 for you guys also.
Okay. What about your
And
community service?
15 hours, Your Honor. They was closed for the holidays, so I really didn't have a place to do it at.
You said you did do 15 hours of community service?
Yes, sir.
Where'd you do that at?
At Helping Hands in Hawkins, the food pantry.
And when'd you get that turned in to probation?
I had seen my probation officer over here in equipment, and that was on the 28th, I believe. I went over there, so I got with her on that. She was supposed to be taking care of that, Your Honor.
So you're saying that you turned it in on the November 28th?
I believe that was the day I went.
Okay. All right, this is what we're gonna do. I'm gonna set you for January 7th.
Yes, sir.
And these are the things that I need done, okay?
Yes, sir.
I need 120 for the probation
Okay.
department. Remember, we're trying to get you caught up on your fines, fees, and all those things. 120 to probation,
Okay.
$80 to court collections,
Okay.
20 hours community service.
Yes, sir.
We still need the medical documents that we
Yes, sir.
still need that. And then we also need you to do a budget form. And,
All right. Yes, sir.
and have your documents that support that budget form. And they're wanting 3 months worth of monthly receipts on your budget form. Do you have your budget form?
Okay. I have a copy of one. I'm sure my Miss Griffith, I can probably get one from her or from my other Wood County officer, Miss Holloway.
Okay.
But I can probably get one.
All right, they want 3 months worth of receipts to support your budget form. Okay.
Okay. Yes, sir.
All right. So here's what we're gonna do. On those first 3, I'm gonna do a 3-day jail buyback. Okay. So what that means is for for the 120, if you don't do all of that, then that's gonna be a day in jail. If you don't do the $80 in court collections, that's gonna be a day in jail. And if you don't do
Okay.
20 hours community service, that's a day in jail, okay? So if every
Okay.
one of those you take care of, then the day of jail goes away.
All right. Yes, sir.
Make sense?
Yes, sir.
All right, we'll see you on January 7th. If you have any questions about any of those things, call Ms. Griffith or call your Wood County probation officer. Probably Ms. Griffith would be better.
All right. Yes, Your Honor.
All right, have a good day, sir.
Yes, Your Honor. Thank you. Appreciate it.
You're welcome.
Bye.
Ms. Sampson? All right, Ms. Sampson, you're here for sanctions court today. Before we talk about sanctions court, do you know what sanctions court is? Do you know what, you don't? Okay, I'm gonna explain it to you, but before we do that, I wanna take a little stroll down how you got here. So back in September of last year, you appeared before the court. You pled guilty to hindering secured creditors, which is a state jail felony that's got that range of punishment of not less than 6 months in prison up to a maximum of 2 years in prison. And that's a state jail prison, which means there's no parole. It means it's day for day. Okay. The court heard the evidence. Court found that you and the DA's office entered into an agreement wherein you admitted your guilt, and in exchange, they recommended to the court that the court not convict you, not put you in prison, but rather to put you on community supervision or probation for 3 years. And then you had your whole list of conditions that you had to comply with in order to stay on that probation. Okay. Sanctions court is a program that is designed to keep people out of court and off of motions to revoke. You know what a motion to revoke is?
Like going against from my conditions.
Yeah, like
Basically.
if there's a violation
Yeah.
or an alleged violation of your conditions, the state could file that motion, could ask the court to revoke your community supervision, to convict you, and to put you in prison for those violations on the crime that you admitted guilt to. All right. And so throughout your community supervision period, if there are violations that the probation department feel that aren't to that level yet of asking the state to file a motion and to revoke you, they put you in the sanctions court program, which is it's really an intervention. It's the court attempting to get your attention that you're heading down a road that you might not want to head down. And it looks like in your case, you're definitely on that road. Says that you admitted to drinking alcohol just a few weeks ago, that you took ecstasy a few weeks ago. And those are violations of your community supervision that the prosecutors here would be well within their rights to file a motion today and argue to the court, if they could prove it, that you're no longer a good candidate for probation, and to just go ahead and hit pause on your life and put you in TDC and let you serve out your sentence in prison. They could definitely do that. Sanctions court is an attempt to get you to understand that you cannot violate your conditions of community supervision.
Right.
Try to keep you out of prison. So the probation department's trying to do that. The court's trying to do that, and they haven't filed a motion yet. So I need to hear from you. Do you want to stay out of prison, or do you want to go to prison?
No, I don't want to go to prison. I don't have no excuse. I kind of let my personal life get in the way of my responsibilities. So I did talk to my my probation officer, and, we discussed about me being on the right path from here on out, so.
So you said you have responsibilities. What
Like
responsibilities?
legal responsibilities, like my community service and stuff like that, and doing what I need to do for my condition.
You understand that your life and your liberty are attached to that. You understand, right? Do you have other responsibilities that aren't legal responsibilities?
Personal issues is,
Do you have kids?
mm,
How many kids do you have?
up to.
You have two. Do you work?
I just started a new job.
Are you supporting your kids?
Yes.
Your kids live with you?
Well, me and their dad, we don't have like a set time or anything. It's just,
Do they live with you some of the time?
well, I have primary custody, but, we don't have any court orders or anything.
That's not what I'm asking. I'm asking, do you have kids that you take care of?
Yes,
Do you have kids that live with you?
yes,
Do you have kids that you have to get up in the morning?
yes.
Do you have kids that you have to feed?
Mm-hmm.
Do you have kids that you have to parent?
Yes,
You have to get them to go to sleep.
yes,
You gotta get them to make right decisions and do smart
Right.
things. You have those things, right?
right. Mm-hmm.
What are you gonna do if you're sitting in prison and they're looking to you for those things? Are you gonna be able to do that from prison?
No, you're right. I agree.
That should be, I understand that sometimes our personal life gets in the way and causes us to make irrational decisions or choices. But when you make a personal decision or an irrational choice, there's a lot of other people that are in that ripple effect of your decision. How old are your kids?
11 and 13.
11. Boys or girls? Girls. Ooh, 11 and 13. Think about how impressionable they are right now.
Right,
They're looking at you for sure. They're looking at you for whatever way they're gonna decide to go. Whether you like it or not. We're all examples, whether we want to be or not.
right.
So they're at a very impressionable, vulnerable age, especially girls at that age. Do you want them to make the same decisions that you've made?
Absolutely not, no.
And do you know why I'm giving you the lecture? Do you know why I'm lecturing you so hard this morning?
I can think of many reasons.
Well, give me one.
Me being tardy,
No?
Mm.
No?
my conditions, maybe.
Yeah. What else? More important than that. Why am I lecturing you?
I'm a mother.
Okay. What else?
Am I wrong?
No, you're not wrong. What else?
Advice.
Okay, I think you're getting closer.
I'm not sure.
I don't want you to go to prison. I give you the lecture in hopes of an encouragement to get you to do the right thing. So the next time I don't see you, you're sitting at a table in an orange jumpsuit and I'm just reading a sentence to you saying you're hereby committed to the custody of the sheriff so he can carry out the prison sentence I just gave you. Fingerprint her, shackle her up, send her off, next. That happens every day in this court. I don't want that to be you. The probation officers don't want that to be you. These prosecutors don't want that to be you. And you know why I know that? Because they gave you the offer in the first place. They
Right.
gave you the chance and they said, here, we're going to give you this gift. What do you want to do with it? Are you going to unwrap it and enjoy it? Or are you going to throw it out the window?
You're right.
So I'm lecturing you hard today because I'm not sentencing you today. I'd rather put in the work on the front end in hopes that we're not having to do this on the back end. And I want you to wake up and understand that this is not a gift that just keeps on giving and giving and giving. So I'm gonna start giving you some court dates and I'm gonna see if you're gonna be able to stay on the straight and narrow
Okay.
and try to give you that encouragement and remind you that if you violate, then you may be looking up to day for day in a state jail prison while your girls are out doing whatever they're doing and their dad's having a parent or whoever else is in your life is having a parent and you're setting that example and losing that very valuable time as a
Right.
mother. Okay. So what I'm gonna do is I'm gonna bring you back. I'm gonna have you come back to court on January. Do you work first of all?
I'm waiting for my new hire, information.
Okay,
on
do you
the
know what kind of
website.
work schedule you're gonna have?
It might be during the daytime. I'm not really sure
Could
yet.
it be in the evenings?
It could be.
Okay. You don't know, is it gonna be a Monday through Friday? Is it gonna be a Tuesday through Sunday?
At this point, I'm gonna be open for pretty much whatever that they have available.
Okay. So tentatively, if your work schedule makes this difficult, then I want you to call your probation officer. Maybe we can move it around, because I don't want you to lose your job.
Okay.
Okay, but in the meantime, until we find out more, I'm gonna have you come back on January 7th. And here are some things that we're gonna do, okay? I'm going to order you to pay your probation fee. You're already under orders to do these things, but these are just, I'm focused in on these things, all right? $65 to probation, $40 to court collections. You've got to do your 24 hours community service. Okay, and we're writing these things down for you. You have to register for your cognitive education class. Okay, you don't have to have it done, but you got to register for it. Get that process going.
Okay.
Okay. And here's the part that you're not gonna like. Okay. You're gonna have to do 3 days in jail between now and January 7th for your drug and alcohol use. Because there are consequences for our actions. Okay,
Do I get to choose, or is it like a set?
I will let you choose,
Okay.
because I want it, not that I want it to be convenient for you, but I don't want it to be inconvenient for you.
Okay.
And so if you serve all three of those in a row on a weekend, that's fine. If you need to spread it out and do, that's fine as well. Because I don't want to interfere with your other life responsibilities, and I don't want to interfere with your job, because I know that you need your job to be able to pay these fees and take care of your responsibilities. Okay, but realize that the leash is very short. It doesn't mean that you drink alcohol, do drugs, and you only do 3 days in jail. This is a sanction saying, look, Shakol, if you continue on this route, they're not going to say keep her in sanctions court. They're going to, instead of walking over here, they're going to walk over there, and they're going to say, we need you to file a motion on her. Here's the things that we want you to prove. And as soon as they file that, it comes to me, a warrant issues for your arrest. You go to custody and we wait for your hearing. Okay? So let's don't get to that point. All right.
Do I need to, when do I need to figure out?
So, well, I'm gonna have you sign this form, and then you're gonna come over here and you're gonna meet with the officers now, and you'll pick out the date. And I'm gonna sign an order. And then on those days, you're gonna take that order, it's got my signature on it. And you're gonna take your ID. And then you're gonna go to the jail, you're gonna do your time, you're gonna get out. And you're gonna do that till you get all 3 days done. And then you need to take care of these other responsibilities and come back on January 7th. Okay?
Thank you.
Mr. Lewis, you ready?
I am.
Come on up. Mr. Wilkins, come on up. This is cause number CR 24-123, State versus Juan Miguel Wilkins. What did y'all decide?
Judge, we have executed a waiver of jury trial. We understand that the plea date is going to be January 7th at 1:30, and we will be here ready for the
All right,
plea.
do you have the document, the waiver of jury trial?
I do, Your Honor.
Yes, Your Honor. Mr. Wilkins, sir, if you'll raise your right hand, I'm going to place you under oath and ask you some questions about this. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes,
All right, you can lower your hand. All right, your name is Juan Miguel Wilkins, is that right?
yes,
And Mr. Wilkins, I've been tendered a document that's entitled Waiver of Jury Trial. Have you had an opportunity to review this document and its contents with your attorney, Mr. Lewis?
yes,
And do you understand that the allegations against you that have been brought by the state, you have the absolute right to have that case tried before a jury of your peers?
yes,
And you understand that during that jury trial process, you also have the right to confront any witness they bring. You have the right to cross-examine them, and also to examine all of the evidence they bring. You understand that?
yes.
Now, you and only you can waive your right to a jury trial. Your attorney, Mr. Lewis, can't do it. I can't do it as the court, and the state can't waive your right to a jury trial. Only you can do that. And in order to do that, I have to be assured that you are doing this intentionally, knowingly, and voluntarily, meaning that you understand that waiving your right means that you're waiving the right to do some of these important constitutional rights in front of the jury. So is that what you're doing today? You're wanting to waive your right to a jury trial?
To be honest, I'm nervous. First time doing this. I have no, I don't know what to do. I really, I honestly don't know. It was said or suggested that it may make it worse. I don't.
Well,
I don't.
okay, well, let's just kind of go through this. So you understand that the state has indicted you for this charge and that they have made you an offer. You have the right to accept that offer. You have the right to reject that offer. You have the right to say, Judge, I want this court to give me a trial. Judge, I would rather have a jury give me a trial. I want to cross-examine the witnesses. I want to hear what they have to say. I want my attorney to ask them questions. I want my attorney to cross-examine them. I want my attorney to bring my own witnesses. I want my attorney to lodge a defense. These are all rights that you have within our criminal jury trial process. You understand all of those things? So what we're talking about here today is waiving a component of that. Okay, waiving your right to a jury trial means that you're telling the court, look, Judge, I understand that I have a right to come in and hear all of their evidence and see their witnesses and see the evidence, and I have the right to contest that and ask the jury to not believe it or to disregard it or whatever. You're saying that I understand I have all that right, but I'm going to waive that because I don't want to go through that process and I want to resolve my case by an agreement. And part of that is waiving your right to a jury trial. And once you waive that right can't be restored to you. All right, that means you can't, let's say, for instance, Mr. Wilkins, you come back on January 7th and you enter your plea and I follow the agreement and it looks like the offer was 10 years in prison and you start serving your prison sentence and then you say, you know what, I don't like this very much. I think I want that jury trial now. That will be gone. That will be gone because you have waived that right. And the only way that you can waive it is that you understand what the right means and that you're waiving that because you understand and appreciate the risks of trial. And you understand that I do not want to invoke that right. That's what that means. And so you have your attorney with you today, Mr. Lewis. Have you had an opportunity to discuss this with him to the point that you understand what your legal rights are and what the waiver of those rights would
Yeah,
be?
we talked. I'm sorry, we talked, yes.
Okay. And so at this point, Mr. Wilkins, can you say whether or not you want to waive your right to a jury trial?
I want a fighting chance, so if that's a fighting chance for me, then jury it is. I mean,
Sure. You would rather take your case before the jury and have your case heard?
yes,
Okay, so what I'm hearing then, Mr. Wilkins, is that you don't want to waive your right to a jury trial and you don't want to enter into a plea agreement with the DA's office.
Correct.
Correct, okay. All right, and so you understand today was the day that the court gave you to see if you could reach an agreement with the state. And it appears, state, you correct me if I'm wrong, but it appears that the state's offer in this case, which is a second degree aggravated assault deadly weapon that has a range of punishment of not less than 2 years or more than 20 years in prison if convicted and sentenced, that their offer on that case was, upon your plea of guilty, their recommendation to the court was that you were going to serve 10 years in prison. Is that correct, State?
That's correct, Your Honor. Thank you.
And was there any other part of the agreement with regards to deadly weapon or anything else?
Obviously,
nothing that we discussed. Nothing that we discussed explicitly, Your Honor.
Okay, and so that would mean, Mr. Wilkins, if you were to be convicted of that type of that offense, aggravated assault deadly weapon, that any sentence that you received you would not be eligible for parole on that sentence until your time served equals 1/2 of the sentence. You understand that? So if you try your case, you could be acquitted, found not guilty. Case would be over. You could be convicted of a lesser offense. You could be convicted of aggravated assault deadly weapon. And depending on what offense you were convicted of, would have a specific range of punishment. If you were convicted of this offense, then you could either select that the jury determine your sentence or for the court to determine your sentence, in which the state would then have their opportunity to present any evidence and argument to the court regarding your sentencing, as would you as well. And then any sentence that the court handed down, and if a jury convicts you, then the court cannot place you on community supervision. You understand that? Once a jury convicts you, the court can't give you probation because of the type of offense. Okay, and so any sentence that you received after that, you would be eligible for parole once your actual time served equals 1/2 of the sentence.
No.
All right, so you
Well,
understand all those things?
You want to ask that on the record? Go ahead with your question.
Oh, I'm sorry. I'm not eligible for probation over, correct?
And as I explained to Mr. Wilkins, that is the state's prerogative, whether they want to offer probation or not in this part of
Yes.
the proceedings. If we move forward into a trial situation, as the judge explained, he cannot
Do probation.
give the jury conviction, he cannot give you probation.
So at this time, you and your attorney have to assess the value of the case in your own opinion, based on what the state has disclosed to you in discovery, on whether or not whatever you value the case at. Because what you said was that if I want a fighting chance. So, that fighting chance is going to be based on your opponent, how much information they have, how they're going to use that, and how you think you're going to be able to defend it. So for me today, all I need to know is, do you understand what the offer is? Are you rejecting that offer? You understand what the advantages and disadvantages of the trial process are, and that you're knowingly taking those on? Or you're saying, I don't want that option, and I want to accept a plea agreement, and I want to waive my right to a jury trial, and I want to resolve the case without a trial. That's what I need to know today from you.
Say I need a fighting chance to prove myself, so.
Okay. All right. So what I'm going to do is I'm going to find that Mr. Wilkins, although he has signed the waiver of jury trial, that he is not requesting that his right to a jury trial be waived today. And the court finds that the state's offer of 10 years confinement in the Texas Department of Criminal Justice on the charge of aggravated assault deadly weapon has been rejected. And I will place Mr. Wilkins on the jury selection docket. And you understand, Mr. Wilkins, that if you later change your mind, let's say in 2 weeks you change your mind and you want to take their offer, I may not allow you to do that because you've said you want a trial. Okay. All right. So what I'm going to do, Mr. Wilkins, is I'm going to set you for jury selection beginning December 9th. What that means is here's the process. You're going to show up on Monday of next week. You'll report downstairs. Ms. Taberham will be down there. She's my court staff, and she will assist you with getting you signed up for your next appearance date. Mr. Lewis is not going to be required to be here because you're not going to go to trial next week because we have other people going to trial. But you're going to continue on that process until your case works its way up and you reach the top 10. Once you reach the top 10 cases liable for trial, Mr. Lewis will be notified. And then you may or may not go to trial on any given Monday when you show up. Okay, you understand all that? All right, so Mr. Lewis, have you filled out a notice of appearance?
I have not, Judge, with regard to the trial.
Okay, let's go ahead and fill that out, have him sign that, and once you sign, then you're free to go.
Thank you, Judge.
You're welcome.
People real quick.
He needs to fill out a pretrial form anyway. They're right.
Say her hand looked like if she were a defendant. Yeah, next to Mr. Schmidt.
Sometimes you can't even tell them apart.
Mr. Schmidt, who are you ready on?
I have Darren Dotson here.
Darian Dwayne Dotson, CR 2497. Mr. Dotson set for docket call.
That's correct, Judge. We'd ask to set Mr. Dotson for a plea on that January 7th docket.
All right, that morning or afternoon?
In the morning, sir.
Court sets Mr. Dotson for plea before the court January 7th at 9 a.m. Once he signs, he's free to go.
Thank you, Judge. Worst case scenario. Good to have them already. Okay. No, he'll be here in January, so. Thank you.
Dotson, be on time next time. Yes. Okay? You're making your attorney's job harder by not being on time. Be free to go. Let's go ahead and call some of your custody people, such as, let's start with Mr. Berkwin, Wyatt Lane Berkwin, CR 24128. So we're set for pre-trial and that he is in the Kyle unit of TDC. So what I'll do is let's reset this for. Is he still on bond on our tape? I show Mr. Brockway is listed. Let me look that up for you. I show him to still be on bond. All right, court finds that Darian Dwayne Dotson is, I'm sorry, not Mr. Dotson, Wyatt Lane Berkwin, that his surety bond, his $5,000 surety bond with Roy Brockway is insufficient, and the court revokes bail and sets new bail at 25,000 cash assured. I'll sign an order reflecting that today, Mr. Chairman. Court will reset Mr. Berkman then for TDC status January 21st. And then I need someone to make a decision whether or not we need to bench warrant him, what you are going to do with the case. And then just notify the court. Court calls CR 24198 Trevian Lakeith Bowie. Court finds that Mr. Bowie is in custody in Smith County. We'll reset that to January 21st. Jail status. Court calls cause number CR 24164 State versus Shunta Rena Foster. Court shows that she's set for arraignment, that she's currently confined in Gregg County, and that we're awaiting a competency status.
She's incompetent by Gregg County. Trying to. I haven't gotten there yet, but.
And Your Honor, I've made contact with Gregg County and I haven't had a chance to share this with Mr. Schmidt yet. I haven't gotten able to or been able to get a hold of the prosecutor there. But I have gotten a hold of Gregg County to try and figure out exactly what they're doing as far as seeking restoration.
All right, then the court will reset this case for status on custody and competency. January 21st. Court calls CR 22-336, State versus Anthony Wayne Murray. You indicated that you believe Mr. Murray is in federal custody.
Yes, Judge. He received I think a 3-year sentence out of the Eastern District, I believe. I did speak to Ms. Curry on that issue and he intends to hold his case, so, but I don't think that it's free to move about.
He may still also be on bond. I didn't know back in April of last year that the bondsman informed the court that the defendant was in federal custody in Pennsylvania.
That's correct, he was.
I don't see a surrender of principal or anything filed, so.
And I think that Judge Reed asked that his bond remain active at this point. I think that he's probably more than halfway done with his federal sentence. And he's looking at a significant amount of time on this case, so we'll probably make it on the file.
You want him to remain on bond in this case?
Yes.
Okay. All right, court will reset Mr. Murray for status on prosecution. Set out a little further. Let's go February 18th. You available that day, Mr. Schmidt? It's a Tuesday. February 18th, and then just ask the state to find out where Mr. Murray is and if you want him bench warranted back before then or anticipated release date.
I don't think the feds will honor our bench warrant.
I think they will. I think they will.
If we can, then I would ask them to be benched if the feds will honor.
Well, I think, we'd probably only do it if we were getting ready for trial, but
I don't really want to get ready for trial.
I don't know that I want to bring him back and house him in the Justice Center, but I know that the feds will release. Ward, Ladarian Ward.
Yes.
He's a NASA, okay, all right. All right, go ahead, we'll call those. We'll call those and we'll get that out of the way. Ladarian Ward. You said he was a hospital. So it's Moreno, Ward. You, Marine. AJ. Joseph Moreno and Morris Moreno. Nobody believes Fabio. Is Mr. Manning still working on Mr. Abbott plea? All right, the court having previously called the name Joseph Blake Moreno. Court finds that Mr. Moreno was not present. His name was called loudly and distinctly 3 times in the courthouse with no response. Court hereby issued judgment nisi alias capable. Court has also called the name Ladary DeAnthony Ward. He was not present. His name has been called loudly distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi alias capable. And also the name Morris Lee Moreno was called, was not present. Name has been called loudly distinctly 3 times in the courthouse with no response. Court hereby issues judgment nisi and alias capable. Mr. Abbott, if you'll come forward, this is cause number CR 24-88, State of Texas versus Emerson Lee Abbott. All right, Mr. Abbott, sir, if you'll raise your right hand, I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So help you God. All right, you can lower again. Your name is Emerson Lee Abbott, is that correct?
Yes.
And Mr. Abbott, are you a United States citizen who reads, writes, and speaks English?
Yes.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning as your attorney?
Yes.
Do you feel like you had enough time to discuss your case and have all of your legal questions answered?
Yes.
Is there anything that you do not understand about what's going on today or any of the paperwork that you signed? Mr. Manning, do you believe Mr. Abbott to be competent?
He is, Judge.
You've explained to him his rights as they pertain to this case.
I have.
And do you believe that he is entering into this plea agreement intentionally, knowingly, and voluntarily?
I do.
All right, Mr. Abbott, you are charged by indictment with a third-degree felony offense of online solicitation of a minor that does carry a range of punishment of not less than 2 years in prison or more than 10 years in prison, and a possible fine not to exceed $10,000. I see the plea agreement in your case is upon your plea of guilty. The DA's office is recommending that the court consider the evidence to convict you of the offense and to assess your punishment today at 5 years confinement in prison. But they're also recommending that the court suspend that sentence and place you on 5 years of community supervision. And they're asking the court to assess a $2,000 fine plus court costs and reimbursement fees. Is that your understanding of the plea
Yes.
agreement? All right, Mr. Abbott, understanding the plea agreement and the range of punishment, how do you plead to online solicitation of a minor?
I plead guilty, sir.
And are you pleading guilty to that crime because you are guilty of committing that crime?
Yes.
And has anybody threatened, forced, or pressured?
sir.
You gotta let me finish because you don't even know what my question is. Has anybody threatened you, forced you, or pressured you to plead guilty?
No.
Court will accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered.
All right, then the stipulation of evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
Rest and close, Judge.
All right, court will consider the evidence. Right, the court, having considered the evidence, finds that there is enough evidence to convict the defendant. The court will follow the plea agreement and recommendation of the DA's office. Court hereby convicts Emerson Lee Abbott of online solicitation of a minor, a third-degree felony, assesses punishment pursuant to the plea agreement at 5 years confinement in the Texas Department of Criminal Justice. The court suspends that sentence, places Mr. Abbott on 5 years community supervision, orders him to pay a $2,000 fine, court costs of $290, and reimbursement fees of $535. The court finds that this offense does require Mr. Abbott to register as a sex offender. Has a copy of chapter 55 been provided to Mr. Abbott?
No, Judge. Copy of chapter 62
I'm sorry.
has been provided, and I have gone over that as well as the admonishments to that end.
All right, thank you. All right, Mr. Abbott, you're hereby remanded to the custody of the probation department so they can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. After that, the probation officers will tell you about what's.
All right.
Who else ready?
Judge, next ready on Miss Prox.
Prox, if you'll come forward. This is cause numbers CR 24-220 and 221, State versus Gina Lynn Prox. So pre-trial, go ahead.
Yes, Judge. Ms. Prox has been trying to get into my office to go over discovery, as well as some possible defenses. And I've been unable to meet with her. She's actually gonna be coming to my office this afternoon to go over that. So we did request additional pretrial. Additionally, Judge, there are several moving parts. We have an offer from the state, and we'd like a little additional time to work through what that offer is gonna look like for her on her next setting. If we could get some additional time, a little bit further in January.
Any objection from state?
No objection, Your Honor. Thank you.
All right, there being no objection, the court will reset pre-trial. I'll have to put her on the evidentiary docket date. Remaining is January 23rd.
Yes, Judge.
That'll be at 9 a.m.
Thank you, Judge. May she be excused?
Yes, free to go.
Thank you, Judge. Judge, I believe that concludes my business this morning. May I be excused?
Yes, thank you, Mr. Mayor. Right there. All right, does that just leave Mr. Holmes?
Yes, Your Honor. I believe so.
All right, this is cause number CR 2455, CR 2456, CR 2457. State of Texas versus Gerald Alexander Holmes. Mr. Holmes, sir, if you'll raise your right hand, I'm going to take some testimony. Sir, do you swear that the testimony you give to the court today will be the truth, whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, you can lower your hand. All right, Mr. Holmes, in each one of these cases, I believe that you are intending to waive your right to a jury trial today. And I want to go over what that waiver means to make sure that you understand it and that you're entering into this waiver intentionally, knowingly, and voluntarily. First of all, you are represented by your attorney, Mr. Richard Schmidt, correct?
Yes, sir.
And have you had enough time to talk with Mr. Schmidt, not only about all of your cases and ultimately what you decide to do in your cases, but have you talked with him today specifically about the waiver of your jury trial in each case?
Yes, sir.
Do you understand that the court can't waive your jury trial? Mr. Schmidt can't, the state prosecutors can't. That's a right that only you can waive. You understand that? You have to say yes or no.
Sure.
And but once you waive that right, if you've done so intentionally, knowingly, and voluntarily, then that right may not be given back to you, meaning you can't change your mind. You understand that?
Yes, sir.
And if you waive your right to a jury trial, you are waiving your right to confront and cross-examine the state's witnesses and evidence against you in front of a jury. You understand that? Now, you still have the right to ask for a bench trial. That is a trial before a judge, and for the judge to hear the evidence and make a decision. But that right, as it pertains to a jury, you will have waived that. You understand that?
Yes, sir.
And you have spoken with your attorney, Mr. Schmidt, about that, and you understand what you're giving up.
Yes, sir.
And you're indicating that you want to waive your right to a jury trial, and so that you can proceed with disposing or resolving all of your cases by a plea agreement. Is that correct? All right, Mr. Schmidt, do you believe that Mr. Holmes is intentionally, knowingly, and voluntarily waiving his right to a jury trial?
I do.
And you've advised him throughout that process before he ultimately made that decision?
Yes, sir, I have.
All right. And so the court will find that Mr. Holmes has been admonished as to his right of a jury trial and finds that he has waived that right intentionally, knowingly, and voluntarily. Court finds that the state has waived its right to a jury trial in this case, and the court hereby approves the waiver of jury trial in each case respectively, and finds that Mr. Holmes will be resolving each case by plea agreement. Court sets Mr. Holmes then to enter his plea before the court on December 17th at 9 a.m. And Mr. Hartwell, I believe you indicated off the record that the state is withdrawing its motion to find bail or bond insufficient for Mr. Holmes based on alleged GPS violations. Is that correct?
Correct, Your Honor.
All right, court finding that that motion is withdrawn and is no longer before the court. Mr. Holmes, once you sign your notice of appearance, you're free to go.
I can see him.
Right, I believe that does conclude our business this morning on the criminal docket, so the court will stand in recess until 1:30.